Hi, my name is Adriaan Smuts from Business Rescue Exchange. Now, in terms of Chapter 6 of the Companies Act, companies can commence business rescue proceedings either voluntarily by the filing of a director's resolution or by an application for business rescue. Now, the application for business rescue is provided for by Section 131 of the Companies Act, which provides that any affected person may apply for a company to be placed under business rescue. Affected persons being shareholders, registered trade unions, or employees that are not otherwise represented by a trade union. In order for an application for business rescue to succeed, the affected person must show that the company is financially distressed, which is usually not a problem. The company has failed to pay over any amount with respect to employment matters, or it is otherwise just and equitable to do so for financial reasons. Then, of course, there must also be a reasonable prospect of rescue. Now, compared to the voluntary filing for business rescue by director's resolution, we believe that when a court considers an application by an affected person for business rescue of a company, the court should determine whether these factors have been satisfied and apply a lenient approach to the interpretation thereof. The reason for that being affected persons such as shareholders, employees or trade unions do not necessarily have inside information, up-to-date financials, management accounts, directors' reports, or any of those information that one would usually need in order to determine whether a company is financially distressed. That being said, when an employee presumes or otherwise thinks that the company that he's working for is financially distressed, we believe that the court should at least, on the facts that the employee or other affected person is able to provide, consider the facts before it and determine whether the company is in fact financially distressed and should be placed under business rescue, applying a lenient approach to make sure that companies that should be under rescue are in fact placed under rescue, and that directors who are unwilling to voluntarily initiate business rescue proceedings are prevented from circumventing the provisions of Chapter 6 to the detriment of all affected persons and the economy as a whole.